Hello fellow YouTubers, and especially my fellow Australians. My name is Randolph Workus, Papa to my children and Mr. Workus to all those under 25. Approximately a year ago I decided to produce a series of video podcasts that would expose blatant cronyism and corruption within the judiciary in Queensland. My videos, when theft is legal, has been viewed thousands of times and been sent to every media outlet in the country. Yet, I have not received one inquiry, no curiosity whatsoever. Yes, I have been cancelled, even though my evidence is irrefutable. I implore you to watch those videos and to share them. Until the media stop treating the public like idiots, nothing will change. Lawmakers and the judiciary answer to nobody. Everything we have ever learned about living in a democracy under a monarch is a fraud, a charade. Please make up your own minds. I am 61 years old. I need to share my experience with every Australian, as this case started in August of 2004. I was only 42. Nearly 20 years ago, this entire event could have been avoided, as the instigator of these frivolous proceedings was a senior property partner of Brisbane's largest law firm. The law was a plaything. It was a toy. The matter could have been settled in 30 minutes, yet a dispute is great for business if you're a lawyer. A bully that used the law to torture us for daring to fight back. Now I am bankrupt, penniless and divorced. It destroyed our family. I lost my businesses, Urban 8 Property Group, Urban 8 Real Estate, a land brokerage company, and I have been blackbanned from my career as a commercial builder. Yet I was the obvious beneficiary, the net beneficiary of the law. These next videos will establish that fact. It was pure lawfare. He used his contacts and lifelong friendships that he had established since university. He was aware of the facts and refused to divulge, contrary to the court order in 2005 by the then Chief Justice Paul de Jersey that guaranteed full disclosure of the facts. This summary is focused on corruption within the legal fraternity and how it was manipulated. It's very important to understand that transcripts are manipulated after the event and are not actual recordings of what occurred. Transcripts are sanitized. They can be used to reinvent the past. It is truly Orwellian. Often the transcript is a Word file, and names make that obvious. Mine was version 3. Go figure. These videos refer to facts including recorded submissions that were sealed. Again, I reiterate, evidence of cronyism is irrefutable. Why won't the media hold the establishment accountable? In March of 2004, my ex-wife and I purchased a parcel of land for $760,000 that was passed in an auction via the public trustee in Queensland because the owner had lost mental capacity and he was forced to reside in a mental institution. We purchased the property with the knowledge that it lacked legal access to the main road, which was called Goldersley Road. It was located in Indooroopilly, Brisbane. At the time, I thought it must have been an error, an obvious error, or a simpler mistake, as it was incomprehensible that a home built in 1947 did not have legal access to the main street. It had a driveway that had been landscaped and had a masonry fence installed across its frontage, abutting the street. Our entire parcel of land was abutted by a common property or a driveway that provided access to another 11 neighbouring lots within an estate called Goldersley Park, which was managed by a body corporate whose chairman lived in that estate. This man was a lawyer and the senior property partner, or the senior partner of the property section of the largest law firm in Brisbane. Let's call him Lawyer Rodney. Unbeknown to me at the time, of purchase of our land, our direct neighbour, Goldersley Park, had been developed by another senior lawyer in the Brisbane legal establishment in the year 1987. If you have seen my previous video podcasts, you will know him as Lawyer Jim. Lawyer Jim had built his own home within the estate and lived there until about 1999. Our land ran parallel to the common property or the driveway into the estate. However, our former driveway boundary of our land dog-legged out towards the middle of the 6 metre wide road, the common property driveway near the main street. My wife and I owned 50% of their access to Goldersley Road. To access their land, one had to drive over our land to enter their property. At the time of purchase, my ex-wife and I wanted to demolish the existing 2-bedroom home. It was a brick and tile home and build a new family residence. There was no point in engaging an architect until we had formalised our legal access. I engaged our lawyer that had extensive property experience who referred me to his easement specialist. Let's call the easement specialist Lawyer Les. Lawyer Les wrote to Lawyer Rodney, the chairman of the body corporate, in August of 2004, requesting a formal access agreement, a reciprocal access over the common carriageway or the roadway that encircled our property. The body corporate inherited an easement known as Easement A over our former driveway, which was landscaped by Lawyer Jim way back in 1987. That easement allowed the body corporate to access their land over our land. It did not give the body corporate permission to landscape it. Our lawyer Les asked the body corporate chairman, Lawyer Rod, for a reciprocal easement which provided access to our land around its perimeter. The existing accessway within the body corporate was burdened by another easement registered to an adjoining property to the west, which was labelled Easement B. In November 2004, Lawyer Rod replied to us, or to Lawyer Les, denying us access. He refused. It was a plain no. Years later, I discovered that Lawyer Rod always knew we were entitled to a reciprocal easement. He always knew. It was pure trail of disclosure. At the time, in 2004, Lawyer Les continued written negotiations and a site meeting was arranged to take place on the 26th of January 2005, Australia Day, between myself, Lawyer Rod and 2 other residents in the estate, Goldersley Park. The meeting was scheduled. I stressed our position that the body corporate would not suffer any financial loss and that we were prepared to assist in the maintenance and upkeep of the common property that encircled our property, that went around our estate. It was unreasonable on any grounds to deny us access to our own land. The conclusion of that meeting was that Lawyer Rodney, as body corporate chairman, would put the matter to the next body corporate meeting, and I should hear back the following April of 2005. No attempt was made to reply. Lawyer Rodney simply ignored me. A dispute is great for business. We financed the purchase of the land and nothing was happening. There was no progress. Lawyer Les wrote to the body corporate several times when ultimately I was forced to bring matters to a head. I had to try and put some urgency into our claim for a reciprocal easement over the common driveway within the estate. I mean, after all, they landscape our driveway. I decided to add some fuel to the fire and fence my own property. We owned the land in the middle of the driveway into the estate. The driveway was 6 metres wide, of which we owned 3 metres of it. We owned half of the driveway access. I arrived on site in mid-September 2005 with a small excavator with an auger, together with a concrete truck at 6 a.m, and I drilled a hole through the middle of the pavement and concreted 100mm square steel post in the middle of the road and installed a safety fence along the boundary of our land and began dismantling the fence that had been erected across the boundary of our land. That prevented us from accessing the main street, or what is known as Goldersley Road. That morning, around 8 a.m, Lawyer Rodney arrived in his big flash Mercedes, stopped, then greeted me with a two-finger salute. He held it high and then waved them at me and drove off. Later that same day, our easement expert, Lawyer Les, received a notification from Lawyer Rodney that the body corporate had sought an urgent injunction preventing us from interfering with their easement A over our land within the Supreme Court of Queensland. Lawyer Les employed a barrister to represent our interests, and the body corporate employed a female senior counsel, a barrister nicknamed then, or still is no doubt, Sheep Station. Both parties appeared before Chief Justice de Jersey, who listened intently to the submissions by both parties and then granted a stay, preventing me from constructing the fence and ordering the body corporate to reveal all prior agreements between the parties and full disclosure of all documents and to begin mediation. Within days of those orders, our lawyer Les received a request from the body corporate asking us to remove the steel post to assist in negotiations, to which I promptly complied and completed. I removed the post. During the following weeks, our lawyer Les wrote to Lawyer Rodney's personal assistant, another lawyer, where he discussed the matter of disclosure and that we wanted to access the Brisbane City Council's records, as it was obvious there was something wrong. Correspondence between the parties continued, and Lawyer Rodney made written decisions that would disclose all relevant documentation. However, access to their council records was denied. I accepted this. I thought that was kosher. I accepted the advice from Lawyer Les. Lawyer Les stated that because we weren't residents within the body corporate estate, we had no formal rights to view their records. The body corporate land was our neighbour's land, so it was private. My view had always been that there must have been an error within the development approval of Goldersley Park Estate. There must have been an error. The mediation process began. We employed a QC who is now a Supreme Court Justice, Justice Martin Daubney. He was our mediator. The process took 3 attempts over many months, where I offered $45,000 and concessions. I needed free access around the perimeter of our land, with access to services including sewer, telecommunications and power. They were all denied. Mediation failed. They did this, which I later discovered was a condition of approval of their estate. They always knew. Lawyer Rodney always knew. Our barrister then put forward a proposal that we submit an application to the Supreme Court seeking an easement of necessity to access our property as our only real option going forward, and suggested I obtain a surveyor to draft 3 different proposals. Proposal A with full access, Proposal B with limited access, and option C, which was minimum access, which provided 6 metres of access to the body of our land, which mirrored the existing easement B. Sheep Station, the body corporate lawyer, had a reputation of playing hardball. She would arrive to court wearing a big trench coat as a uniform, and I always knew there was very little prospect of a reasonable settlement, but we pushed forward with the application in court seeking an easement of necessity. Thousands of dollars were wasted in lawyers' fees, where proposals were submitted when I realised if the matter was heard and option A and B were refused by the justice and forced us to accept option C, I ran the risk of having to pay all of Sheep Station's costs. Ultimately, I accepted easement C that was very limited. Please remember that I'm trying to simplify the bastardry that took place over 4 years, a 4-year period, as there were many hearings and ultimately no disclosure by the body corporate, Sheep Station or lawyer Rodney. Financing these proceedings while servicing debt is impossible to convey in words other than I was forced to liquidate other properties at fire sale prices, and I was forced to work 7 days a week, missing out on watching my children grow up and participate in weekend sports events. The stress is impossible to convey, but apparently it simply doesn't matter. After 3.5 years of pure stress, we reached a resolution of the dispute. Easement C over the smaller version of the original proposal with no access to services. It took another 4 months after that lawyer Rodney to sign the paperwork. There was no hurry to help us. It was pure bastardry, paying interest every month. As a developer, I knew that I could still recoup some losses by subdividing the land and placing another private driveway across the rear of our land, and then to create our own body corporate, which would share the existing utilities that serviced our land, but that was a very, very expensive option. I trusted our lawyer Les. We had wasted a huge amount of money, well in excess of a provable $1 million, which was nearly impossible to quantify. When you're being screwed over, how do you know? Ultimately, I asked our surveyor to submit a development application to the Brisbane City Council to subdivide our land as a body corporate, what's known as a group title plan, which was quickly approved with conditions. I was so elated, as finally we could move forward with our lives, when the surveyor explained that I needed the permission from the body corporate to discharge our stormwater onto the body corporate's common property. Give me a break. I nearly died. There was no way they would agree to do that. The bastardry would continue. I was dumbfounded. I rang lawyer Les to tell him the news when I was informed by his assistant that lawyer Les was on holiday, and the assistant put me through to a new lawyer that had been a former government barrister, who quickly suggested that because the body corporate's land was below ours, there must be some provision within their development approval to accept our stormwater. When he suggested we could submit a Freedom of Information search to the Brisbane City Council, I asked him how much would that cost, and he suggested, well, $1,500, which I agreed to pay. 2 days later, I received the FOI search with a plethora of information, including written communications as early as December 1986 from the Brisbane City Council to the architect that the design must comply with the new City Town Plan of 1987, together with a copy of the 9th of July 1987 development approval of our neighbour's property. The development approval listed conditions, and conditions B and conditions G included an access easement over the common property of the group title plan in our favour. It was a condition of approval. I couldn't believe it. We were always entitled to that easement. 4 years of proceeding. They always knew, and the unquantifiable stress was all in vain because our lawyer Les didn't think to complete our FOI search and believed that I needed body corporate permission to view the original development approval. It was a nightmare. Upon further investigation, the FOI search only cost $35. Now I ask you, if your lawyer wasted over $1 million of your money and wasted 4 years of your life, put you through this stress, and you were forced to liquidate assets and work 7 days a week, would you want your money back? It was pure negligence. After much inquiry, I was referred to by my civil engineer at the time to a friend of his. Let's call him Lawyer Tom. I knew Lawyer Tom was a friend of his. He had integrity and apparently he was very astute. After several meetings with Lawyer Tom, Lawyer Tom submitted written advice that it was a clear case of negligence and recommended that we sue both our former lawyer, Lawyer Les, and the body corporate, as they were obligated to know what their obligations were towards us as a neighbour. Lawyer Rodney always knew we were entitled to an access easement, which means that Sheep Station knew, she must have known, it was pure bastardry, it was tyranny, it was a pure misuse of the legal process and designed to exhaust us of our financial resources. It was hell. Welcome to my nightmare. And the cronyism entrenched within the Queensland judiciary. You will discover in part 2 they are all friends and there is absolutely nobody to complain to. Please like and subscribe to my YouTube or Rumble channel, or visit our website whentheftislegal.org to access the original 12 videos so you can see the entire story. And please sign our change.org petition so you can learn just how corrupt Lexon Insurance and the Queensland State Government really is. See you again soon, and always remember, she'll be right, mate. Never fear, Randolph is here. Thank you for listening to me.